drop them off, go stop in and see everybody. Some of the vendors, I believe, have some baskets or some surprises. Please feel free to fill those in. Let's say hi to Matt.
There it is. Thought she stole the clicker. All right, good morning. All right, the superheroes in the latest Avengers movie. How many people saw it this weekend? No, it's not the crowd, is it? Okay. All right, well, I'll tell you that in the movie, there's a villain called Ultron, who seeks to destroy the human race. Basically, that's the plot of all these movies. You see, Iron Man, Thor, Captain America, the Hulk, and a bunch of others all band together to fight this Terminator-styled villain. It's a machine. Those of us who are representing elderly clients are battling our villains like Ultron each and every day. Now, these villains are usually the frustrating laws and regulations that thwart our clients' ability to get the services that they need. Whether it's the big bad Medicaid program, Medicare, Social Security, we need superhuman powers to battle these bloated bureaucracies. So today, I'm going to give you some ammunition to battle these menaces to our clients. Ammunition in the form of some knowledge that you can take back to your jobs. As Hulk might say, smash all these obstacles that you are going to face. In addition, I'm going to test some of your knowledge about the superheroes, the movies, and the actors who are portraying them. So a bit of movie trivia to keep your attention between the doses of the ABLE Act and veterans' benefits. So let's begin with our first topic, the changes to our power of attorney law. Now, the new law came out of some legislation that was known as Act 95 of 2014. The Act changes some of the existing laws with regard to financial powers of attorney. Our legislature took up the cause of changing our power of attorney law in response to a case involving a woman named Teresa Vine. You see, Ms. Vine had suffered a stroke, and shortly thereafter she signed a power of attorney. Her agent named in that document then went on to harm her financially. Although the power of attorney on its face appeared to be very valid, it was later discovered that Ms. Vine didn't know what she was signing and didn't fully appreciate the powers she was giving to her agent. So one of the goals of the new law is to try and curb the number of financial powers of attorney that are signed under rather suspicious circumstances. The law also requires those who are signing these documents to make choices about the powers and the duties that they're granting to their agents. Furthermore, the legislation is intended to protect third parties, like the banks and insurance companies, from liability if they're asked to honor these powers of attorney. Although well-intended, the new legislation makes powers of attorney more complicated and sometimes confusing. More than ever, the stock powers of attorney are going to be proving to be inadequate for a lot of our clients. If they rely on form documents, they risk having a document that won't allow them to properly manage their affairs. Now, most of these changes to the law become effective on January 1st of 2015. They don't apply to most powers of attorney that were signed prior to that date. So, here are some of the changes to the Act. One of the big changes is how powers of attorney are going to be signed from this point forward. First of all, if you have someone that is going to sign on behalf of the principal, it can only be done if the principal is unable to sign and specifically directs another person to sign the document for them. Second of all, the signature or mark of the principal now must be acknowledged before a notary. Most powers of attorney always had a notary if they were notarized in an attorney's office, but it was not required under the law. And last of all powers of attorney must be now witnessed by two individuals, neither of whom is the agent. First superhero fun fact. Did you know that James Spader, pictured here, is voicing the character of Ultron in the new Avengers movie? You may know him from the TV show Blacklist. I also understand he was on Boston Legal, yes. Now, my first recollection of him as a character in the movies was as this character, whose name was Steph. This movie was from the 80s. That great 80s hair. I'd love to have that today. I didn't appreciate it when I should have. Can you name the movie where Mr. Spader played this character named Steph? It was an 80s movie starring an 80s it girl. That woman right there raised her hand. What was it? Pretty in Pink, yes. All the girls from the 80s knew that movie. Some more questions about that movie. Do you know who the leading man was and the leading lady? Who were the actresses? Molly Ringwald. That's James Spader. Andrew McCarthy, very good. According to Patty Jo Turner, he was dreamy. I don't know, but she says he was. Now, the movie also, surprisingly, included an actor playing a character named Ducky, who just finished up a run in a long-running TV show all about men. Do you remember the actor's name? John Cryer, that's right, and it was 2.5 Men. It's interesting that the supporting actors, like Spader and Cryer, went on to have successful careers, where the leading people did not. All right. Now, financial powers of attorney are not as pretty as the big 80s hair, but since 1998, they have included a big, ugly notice and acknowledgement page. On the front of the document, there is a notice in bold, underlined type that warns you about the powers that you're giving away. On the back page is an acknowledgement that warns your agent about the duties that they have. Well, too many of these powers of attorney have been used to change estate plans, contrary to the principal's desires, as it was the case in the Teresa Vine matter. So the legislature decided that those signing powers of attorney need to be warned that their agent has the power to make major changes to their estate plan. The new warning in this notice gives the agent, states that the agent may be granted the broad authority to give away your property or make changes to how your property is distributed at death. The agent also has to acknowledge that he or she has some important duties to manage your affairs. Some of this, of course, seems like common sense, but it puts in writing that the agent cannot act in a manner that benefits the agent and not the principal. It helps to prosecute those wayward agents who abuse these documents. So the new language requires the agent to act in accordance with the principal's reasonable expectations, to the extent known, and otherwise in the principal's best interest, and of course within the power granted in the power of attorney. The standard of conduct cannot be waived, and the agent cannot act for the principal without first signing this acknowledgement page. Now, under the new law, agents have other numerous duties that they have to follow when acting on behalf of the principal. Sometimes clients want to waive these duties because they can be burdensome for the agent or conflict with estate planning goals. The new law now allows these duties to be waived. I often see these duties waived for somebody who's really well trusted by the principal. Perhaps it's a spouse or an only child. The goal of waiving them, of course, is to give the agents the very broad powers and not tie their hands when they are engaging in financial management of the principal's affairs. Now, if the agent is not as close, or perhaps there's a likelihood of conflict within the family, these duties are unlikely to be waived. Here are some of the duties, however, that could be waived if the principal desires. First, the keeping of records. Of course, this is logical if maybe you name one of your kids and you want to make sure that they will account to the other kids if they want to know what's going on with your monies. But it makes little sense when you have a spouse or maybe a trusted child who's going to inherit anything anyways. So often, your monies are not, it's not necessary to keep records of what's going on with your finances if the person you're naming is so trusted that you feel it's too burdensome. Well, keep the agent's funds separate from the principal's funds. You generally don't want an agent commingling their money with yours. However, there may be cases where this duty would interfere with asset protection planning, so it is a waivable duty. And a new duty is the preservation of your estate plan. You really have to think this one through. If this is a duty in the power of attorney, the agent shall attempt to preserve your plan of distribution at death. There are some factors to be included in evaluating this duty. They include the value and nature of your property, the principal's foreseeable obligations and need for maintenance in the future, minimization of taxes, and eligibility for benefits like Medicaid. Some attorneys are concerned that including this duty might hamper estate and benefits planning, so it may be advisable under certain circumstances to waive this particular duty. Before we get to the hot powers, we need to go back to the 80s for the hot young Brat Pack stars of the day. As you know, Robert Downey Jr. and James Spader star in the Avengers blockbuster. But can you tell me what 80s movie they both appeared in where Downey was a drug addict, as pictured here, and Spader was once again a bad guy. This time he was a drug dealer. And I'll give you a hint, the Bangles covered a Simon & Garfunkel tune on the soundtrack. This woman, again, is a big 80s fan. And I will pick on you, go right ahead. Less than zero. Kind of a very serious, somber 80s movie. Doesn't have a happy ending. And the song that they covered of Simon & Garfunkel's, it was not Sound of Silence. Bridge Over Troubled Water, no. The Boxer, forget it, no. Scarborough Fair, no. How about Hazy Shade of Winter? I remember this in the video, yes. Interesting note about the movie, it was in a book. It was penned by an author named Brett Ellis. He also did another really happy book called American Psycho. And in that book was also made into a movie, and a gentleman named Christian Bale starred in that one. Do you know who Christian Bale went on to become as a superhero? Batman. Interesting, Brett Ellis pens 2 books, they're made into movies, 2 actors star in them, and they both go on to become superheroes. From hot stars to hot powers, here's one of the big changes in the powers of attorney that you will see drafted after January 1st. Many powers in the document you will now need to expressly grant, or your agent will not have the authority to use these powers. In the past, you had some of these powers by default. However, there were cases of financial abuse through the use of one or more of these powers, so now the legislature requires you to choose whether you want them in your document. The drafters are informally calling these hot powers to signify the importance to the party granting them. There are 8 such powers. I'll tell you about 4 of them. First of all, to make a gift. This has actually been a hot power since 1998. If you want somebody to give your money away, or even take your name off an account, or perhaps a piece of real estate, and this could be your wife, quite frankly, you need to give them the power to gift your property. And you need to define the amount of the gift. It could be a very limited amount, or it could be an unlimited figure. And you want limitations on the power as to who they could give your property to. Maybe it's just your wife and children, those in your estate plan. You need to define that in the document. So gifting remains a hot power. To change or create a right of survivorship, such as a bank account. This goes on all the time. Most banks are aware that kids come in, they want to put their name on mom or dad's bank account. Well, from January 1st forward, you're going to have that power in the document if you want to add your name to your parents' bank account. If the power is not in there, the banks are authorized to say, no, you don't have the power to put your name on a bank account. To change a beneficiary designation, like in a life insurance policy, who will inherit the money in this policy at your death? Powers of attorney were authorized in the past to change beneficiary designations. Now you've got to affirmatively decide whether you want that power in the document and how the authority will be granted. To anybody at all? Do you want it in accordance with your estate plan? You've got to spell it out. To create, amend, revoke, or terminate a lifetime trust. Trusts are estate planning devices, and the reason for creating them are very many. But in the new law, you can now authorize your agent in your power of attorney to create trusts for you of any kind and under any terms that you decide. So as you can see, these are rather powerful tools. They're often used in the estate planning world. The law goes on to restrict who can actually use these hot powers to close family members, but you can opt out of this provision and allow anybody to use these powers for you. All of the powers of attorney drafted after January 1st will need to expressly grant these powers. If you don't do so, you will have a very conservative power of attorney that will restrict your agent's ability to engage in estate planning on behalf of you. The new law addresses some of the problems raised by the Teresa Vine case. One of the fallouts from that case was that third parties who accept powers of attorney that later turned out to be void could be held liable for damages. This put third parties like banks and insurance companies in a difficult position. They could really not have known whether Teresa Vine's power of attorney was signed while she was competent or incompetent. So the law attempts to give third parties immunity from some of these claims. Now, the law, in fact, goes beyond a Vine fix and provides third parties with a number of options to make sure the power of attorney is valid before they honor it. The options include the right to request additional information from the agent, such as a certification of certain factual matters. They can also ask for an opinion of an attorney that the agent is, in fact, acting within the scope of authority granted by the document. Then the law does also rewrite provisions related to liability of a third party who refuses to accept a power of attorney. It does narrow the scope of damages to those economic damages that are what they call proximately or directly caused by someone's refusal to honor the power of attorney. Now, here's a big question. Given the recent changes in the law, are the old powers of attorney that are out there going to be honored by banks and investment companies, life insurance companies, that will need to see the power of attorney before your agent can act for you? As I mentioned, the new law does give these institutions broader authority to reject old or questionable powers of attorney. If in good faith they believe the power of attorney is not valid, such as it doesn't have a hot power, they can reject your attempt to use the document. The law also gives financial institutions greater protection from damage claims for refusing to honor them, so they may very well be emboldened to reject more powers of attorney. So given the new provisions in the law, such as the duties and the hot powers, it is likely that more and more boilerplate and old powers of attorney are going to be rejected. The third parties' heightened awareness of financial abuse of the elderly have caused them to be a lot more concerned about honoring documents that don't comply with the law. The bottom line is that if your client has an older financial power of attorney, it is recommended that this is the time to get it updated. There are added protections for your clients in the new law and clear instructions that will help them manage, them and third parties manage their affairs in the future. Transforming, like Dr. David Banner to the Hulk. The current Dr. Banner is played by a really likable actor named Mark Ruffalo. However, my earliest recollection of the Hulk, beyond the comic book, was the TV show that starred the late Bill Bixby as Dr. David Banner. My question for all of you, and hopefully someone other than you knows the answer. This is a 70s question. Does anybody remember who played the Hulk on the TV show? Somebody said Lou Ferrigno. You are right. That's right. Lou Ferrigno was a bodybuilder. That was his original claim to fame. And he starred in a documentary with what other very famous bodybuilder? Arnold Schwarzenegger. That's right, the Governator. And the documentary was known as Pumping Iron. You may want to check that one out. Yeah. I read online that Lou Ferrigno's voice is used as the Hulk's roar in the current Avengers movie, so he still has work, and probably more than Andrew McCarthy. The more relevant transformation for us is the transformation of the Department of Public Welfare to the Department of Human Services. Last year, the governor signed into law a change to the department's name. The department, of course, oversees a whole host of services that have little to do with what people traditionally think of as welfare. So I'm sure many of you have met clients who disdain the use of welfare services despite the practical need for them. So the welfare stigma was a prime motivator for the name change. Now, the change will be phased in slowly to reduce costs. If you see a reference to the Department of Public Welfare somewhere, it's going to be deemed as a reference to the Department of Human Services. When we last visited the expansion of Medicaid coverage under the Affordable Care Act, Governor Corbett had submitted his request to the federal government for a modified Medicaid expansion known as Healthy Pennsylvania. His plan involved two parts. First, there were changes to define who was going to be eligible for the Medicaid program. And secondly, there was a demonstration project that waived some of the normal Medicaid rules and allowed some of our residents to acquire those private managed health care plans under the Affordable Care Act. The demonstration project was known as the private care option. Well, actually, the Healthy PA plan was rolled out late last year, and the rollout did encounter some glitches in its implementation. And then shortly thereafter, the newly elected Governor Wolf put a stop to Healthy PA. He fulfilled a campaign promise and had Pennsylvania join the expanded Medicaid coverage as defined under the Affordable Care Act. Now, the transition to the expanded Medicaid coverage is being divided in two phases. The first, which is ongoing right now from April to June, will be for those who are enrolled in the General Assistance and Select Plan from the private care option. They will be transitioned to the new Medicaid adult benefit package, which they call Healthy Choices. Also, all new applicants who are enrolling in Medicaid are going to be enrolled in this new adult benefit package called Healthy Choices. Phase 2 will start in July and conclude by September, where all the remaining enrollees in these private care option plans are going to be transitioned to the new Medicaid plan. Well, Pennsylvania has enacted a new law that requires healthcare practitioners to provide educational information to parents who receive a test result that is positive for Down syndrome. Dubbed Chloe's Law by its sponsors, the Down Syndrome Prenatal and Postnatal Education Act was signed by Governor Corbett last year. In the law, it is required that upon receiving a test result that is positive for Down syndrome, healthcare practitioners must provide the expectant or new parent with educational information that's being made available by the Pennsylvania Department of Health. The information that is to be developed by the Department of Health will include some evidence-based information about Down syndrome. The information must also include some contact info for support services, relevant resource centers, and Down syndrome organization. The law did face some controversy. There was opposition to the law by the American College of Obstetricians and Gynecologists on grounds that it interfered with the physician-patient relationship. The law was also opposed by the Pennsylvania Medical Society. However, given the fact that it was an informational law, it overwhelmingly passed both the House and the Senate. The Pennsylvania House of Representatives has unanimously passed some legislation in support of senior respite services. The legislation authorizes the licensing and oversight of community adult respite service programs. These programs are intended for seniors who are living at home and require only minimal assistance. They provide the senior with social interaction, exercise, and cognitive stimulation, and the hope is it will enhance the potential for longer-term independence. And respite programs, of course, provide family members with a much-needed break from caregiving duties. Program participants must be age 60 and older and be able to passively or aggressively, actively or passively, engage in social and leisure activities. Participants may suffer from mild cognitive or physical impairment, but the program is not intended for seniors with higher care needs, such as individuals needing assistance with medication, individuals who need personal hygiene care, or present a risk of wandering. Participants would be subject to an ongoing assessment. Those who develop more intense care needs would then be transitioned to other providers. The legislation would clear the way for senior centers and other providers to offer senior respite services. This will hopefully allow for the geographic expansion of respite care to senior centers across the state of Pennsylvania. It may encourage other nonprofit or for-profit organizations to offer similar programs. Licensed long-term care service providers will be able to provide senior respite services without a separate license. But they must notify the Department of Aging of their intent to operate such a program. Other providers are going to have to obtain a license. Monitoring of the program is going to be provided by the Department of Aging or the local area agencies on aging. This bill, House Bill 1702, now moves on to the Pennsylvania Senate, where the prospects for passage appear rather bright. With bipartisan support and no public funding requirement, the bill may be on the governor's desk this year. The Long-Term Care Commission issued its final report late last year. The report included the proposed recommendations to improve the state's long-term care system. The report was issued in December and accepted by then Governor Corbett. The commission found that the long-term care system had many challenges. They included a lack of coordination as well as some lengthy and complicated eligibility processes. This led to the development of 4 broad recommendations to address these challenges. They suggested improvements in the following areas: care coordination, service delivery strategies, quality and outcomes, and also to make the system more fiscally sustainable. One of the recommendations in the report was to have Pennsylvania participate in what is called the Community First Choice option. If you recall, the Affordable Care Act provides state Medicaid programs with several options for expanding home and community-based services. One such funding option was the Community First Choice option, which gives states additional federal matching funds for providing attendant care services to Medicaid recipients with severe physical or intellectual disabilities. In addition to the enhanced federal funding, other highlights of the Community First Choice option include: there are no caps on the number of people who would be eligible for attendant care. Pennsylvania would basically have to offer these services to all eligible persons on Medicaid without any waiting lists. This differs greatly from our waiver programs, where the number of participants is capped. Although the services provided under the Community First Choice program are more limited than those provided under the waiver programs, this option would at least provide some basic support services for individuals with disabilities who have no other services at this time. Now, the type and amount of the services someone can get through the program would be determined through a person-centered planning process. Once they develop a plan, the services are to be self-directed, with the state having the option of allowing eligible persons to hire, train, fire, and determine the pay rates for their attendance. And there will be a medical expense deduction for those who want services through the Community First Choice program. They will need to qualify for Medicaid. As you know, there are some income limitations for those who want to qualify for our waiver programs. However, the Community First Choice program will allow the deduction of an individual's medical expenses from their countable income when determining financial eligibility. So that process is going to be very similar to the process used for qualifying somebody for Medicaid to cover skilled care in a nursing home. There was one program that Hulk could smash over the last year, it probably would have been Medicare. That program had the most frustrating policies, and it angered everybody from doctors to patients alike. Here is the most recent Medicare issue. Just last month, the president signed legislation to permanently fix the payment system to doctors under the Medicare program. You see, since 1997, doctors were paid by Medicare under a formula that tied their payment to the state of the economy. For the first few years, the formula tended to be fairly accurate. However, as healthcare prices rose, much greater than the general economy, Congress had to make annual adjustments each year to prevent cuts in Medicare payments to the doctors. Thus, they called it the doctor fix. These adjustments have grown each year. If Congress didn't fix the payment system in 2015, the potential cuts could have been 21%. There was the fear that doctors would stop accepting Medicare payments if that had occurred. So Congress agreed to change the way doctors were paid under the program. The legislation scraps the old system and gives doctors a 0.5% bump in their fee for each of the next 5 years. Medicare will also transition to a payment system designed to reward physicians based upon the quality of their care rather than the quantity of procedures they perform. The new system is also intended to encourage better care coordination and chronic care management. It would give a 5% payment bonus to providers who receive a significant portion of their revenue from alternative payment models or patient-centered medical homes. How is all of this going to be paid for? Well, mostly by higher wage earners. Starting in 2018, wealthier Medicare beneficiaries would pay more for their Medicare coverage. And starting in 2020, the supplemental Medicare insurance, known as Medigap, would not be able to cover the Part B deductible for new beneficiaries. That deductible is currently $147 per year. And finally, post-acute providers, such as long-term care and inpatient rehab hospitals, skilled nursing facilities, home health and hospice organizations, all of you would help finance the doctor fix by receiving base pay increases of only 1% in 2018, about half of what was previously expected. So they took from Peter to pay Paul. Hulk smash. Yes, Hulk smash indeed. All right, the Center for Medicare Advocacy filed a nationwide class action suit. It was called Lessler versus Burwell, on behalf of some plaintiffs who have waited longer than 90 days to get a decision from Medicare administrative law judges. The average wait time for these appeals is currently 5 times the statutory limit. Most of you are familiar with the first 2 levels of appealing a Medicare decision. They are the redetermination and then reconsideration phase. At the next level, the ALJ hearing, an appellant is allowed to present evidence before a judge. It's the first meaningful review. Over the last 5 years, the reversals of the redetermination and the reconsideration levels is less than 5%. So the ALJ level of review is particularly important to our clients who have really legitimate appeals. Virtually every appellant has had to wait longer than 90 days to get an ALJ decision. Think of what that does for the relationship between the provider and the patient. Some clients go for a long period of time without getting care, and perhaps in some cases providers go without getting paid. The need for efficiency in these appeal systems is heightened by the ongoing struggle to make sure that the new Medicare standard is being implemented. If you recall, the historic settlement in the Jimmo class action lawsuit brought to an end the use of the improvement standard as the only standard of review in Medicare cases. The settlement agreement was signed back in 2013. Since that time, CMS has been slowly complying with the settlement terms. First, they updated the program manuals. CMS Transmittal 179 reinforced the terms of that settlement, that the improvement standard should not be applied in determining Medicare coverage for maintenance claims that required skilled care. Then CMS rolled out an educational campaign that was aimed at providers and suppliers. Lastly, there were re-reviews of claims that were based solely on the improvement standard. Now, Mrs. Jimmo, who started all of this with her lawsuit, had her claim resubmitted for review. And much to her surprise, she was still denied Medicare coverage. And that, of course, prompted another lawsuit, and Ms. Jimmo finally prevailed. So it's really not clear to anybody whether the change in the law has trickled down to the providers. My clients appear still to be subject to denials based upon the improvement standard. It's possible they just don't know to ask about coverage of maintenance services that are designed not to improve their care but maintain a level of function. Hopefully, more and more providers of services, from the doctors to the facilities, will see the benefit in pushing through Medicare claims using this new standard. The standard can not only provide valuable services to our clients, but additional Medicare coverage for the service providers. Classic Superman, my first recollection of a superhero movie. Remember Marlon Brando as his dad in the first movie, way back when? Lex Luthor was played by what legendary actor? Gene Hackman. Gene Hackman was Lex Luthor, and Ned Beatty was his henchman. Now that was classic casting. And Christopher Reeve, I think, was still probably the best Superman. He was really perfect in that first movie. Sadly, Reeve, if you recall, was paralyzed in a horse riding accident. He died relatively young. If he were alive today, I can imagine him advocating for what is called the ABLE Act. It's a new law that can assist people with disabilities. The ABLE Act is actually part of the Internal Revenue Code. Section 529A of the code authorizes the creation of a tax-free savings account for those who became severely disabled before the age of 26. The concept is to allow those disabled individuals to save money for their own use without affecting their benefits like SSI or Medicaid. There will not be any tax on the earnings in these accounts, and they should be as easy to set up as any bank account. Now, if you were disabled before the age of 26, you can qualify for the creation of an ABLE account in one of two ways. One, you can establish that you are receiving SSI or SSD. Two, you can get a doctor's certification saying that you meet the medical criteria for receiving SSI or SSD. Now, the money in the ABLE account can be used for what are called qualifying disability expenses, including education and housing, health expenses, transportation, personal support, and so on. Each state needs to set up legislation to participate in the ABLE account. Pennsylvania has introduced legislation to authorize the use of these accounts. Given the rather uncontroversial nature of the legislation, we all anticipate it's going to pass in the relatively near future. Now, there are some less than attractive aspects of the law that make the use of the ABLE accounts inappropriate in certain situations. The first is the age limitation. So if somebody suffers an accident or disability after the age of 26, they're not going to be able to use these accounts. Secondly, there are some funding restrictions. You cannot exceed what they call the federal gift tax exclusion. So that's $14,000 per year right now. And if the value of the account goes over $100,000, it will be considered a resource for the purposes of eligibility for SSI. Surprisingly, it's not going to be considered a resource for Medicaid purposes. And there is a payback provision for these accounts. At the death of the person who created the account, there will be a Medicaid lien on the balance left in the account. So, in some cases, these accounts won't make a lot of sense. If third parties like parents or grandparents want to give money to their disabled child, a fair amount of money, then they need to be advised to set up probably a third-party special needs trust. There's no payback provisions in special needs trusts set up by third parties, and the trust income tax obligation of these trusts is usually inconsequential. ABLE accounts really make sense for those higher functioning, disabled individuals who want to earn a wage and not lose their SSI or Medicaid. They can now save well in excess of that $2,000 limit and keep their benefits and hopefully live a more comfortable and independent life. Captain America, one of the original superheroes. He's played in the Avengers by actor Chris Evans. Captain America is a genetically engineered super soldier. Interestingly, another character in the Avengers is Hawkeye, played by this actor, Jeremy Renner, who recently starred in the Bourne Legacy, a movie about genetically engineered assassins. As you know, Matt Damon made the Bourne series a big hit with the character of Jason Bourne. Did you know his old friend Ben Affleck will be starring in a superhero movie? Do you know which character he's going to be taking on? Batman, that is right. God help us. Yeah. I could go on and on with this trivia, but I have to tell you that Captain America would probably be interested in the new VA regulations related to the pension benefits for our veterans. The Veterans Administration has proposed some changes to the qualification rules for veterans' pensions. The most popular of these pensions for our purposes is called aid and attendance. It is used for our older clients who are in need of long-term care, either at home or perhaps in a facility. For those veterans who qualify for the pension, it can be up to $2,150 per month. That can go a long way to help defraying the cost of care at home or perhaps in an assisted living facility. Now, there are resource and income qualification rules for aid and attendance. In January of this year, the VA proposed changing some of those rules. If they become law, it will make qualification for these pensions much more difficult for our clients. Here are 3 big changes to these rules. First, the VA is going to define net worth when qualifying for the pension. In the past, the amount a spouse or a couple could keep while qualifying for the pension was rather unclear. We often felt it was $80,000, but in some cases they told us it included a year's worth of income of the veteran. And then in some cases they told us it was dependent on how old the veteran was. You never really could get a clear answer from the VA. So what the VA is proposing with these new rules is that net worth is essentially going to track the Medicaid long-term care rules associated with resource allowances for couples. So if you have a couple that has $100,000, they cut that number in half, and that's your resource allowance for Medicaid purposes. Unlike Medicaid, the VA will add the veteran's annual income to this total. Now, the resources used to calculate the net worth for veterans' pensions will essentially track the Medicaid rules. For example, the house will still be considered an exempt resource. The second change is closely related to the calculation of net worth. The VA will allow out-of-pocket medical expenses to be deducted from income when calculating net worth. This will allow veterans with higher income to qualify for the pension. One of the problems seen with the proposed regs is they're not as clear as they should be. From what we're reading, some of the proposal doesn't cover all of the payments to assisted living facilities. I'm sure that will be worked out in the negotiations as the legislation gets to Congress. Now, the big change in the regs will be the creation of a transfer of asset penalty. There will be a 36-month look back for transfer of assets. And there will be a penalty levied for a transfer of assets during that look-back period that reduces the veteran's net worth. So not all the assets are subject to the penalty, only those that reduce the net worth. The VA calls these covered assets, and the penalty is going to start on the month following the date that you made the transfer. So the rule is like the old Medicaid rules. Okay? When calculating the penalty, they are going to use a divisor equal to the maximum monthly pension rate, and the penalty can be no longer than 10 years. Prior efforts to pass similar legislation have failed in Congress. However, the VA is clearly not giving up, so it's probably just going to be a matter of time before these changes become part of the pension program. Remember when Michael Keaton was one of the hottest actors around? Again, I'm going back to the 80s. In the early 80s, through the early 90s, he had a lot of hit movies. He was a funny guy. He was in Late Shift, Mr. Mom, Beetlejuice, and of course, that first Batman movie back in 1989. Then he cooled off, had some movies here and there, but wasn't as big. Can you tell me, if you're a fan of the Toy Story movies, what toy he did the voice for in the last Toy Story movie? It was Toy Story 3. I know, I watch too many movies. It was the Ken doll. He was the voice of the Ken doll in Toy Story 3. And his latest movie, Birdman, really got him back into the news. He played an aging actor who was trying to overcome his past. In the movie, he once played a superhero named Birdman. Kind of a play on his Batman, I think. Well, the aging superheroes of the world might be interested in the next topic, how best to take your Social Security. We see a lot of clients who are contemplating retirement, and when should they be taking Social Security, early, late? The date when they take Social Security can be one of the most important retirement decisions that they can make. And here's why. For the boomers born between 1943 and 1954, the full retirement age is 66. Yeah. If you claim before the full retirement age, you receive reduced benefits. The longer you wait, the more your monthly benefit can increase. Keep in mind, for those who take an early benefit, the reduction is permanent, and the decision may very well affect your spouse's benefit if he or she would have drawn on your higher survivor benefit. Unfortunately, claiming early is very popular. The SSA reports that 74% of retired workers elect to claim early benefits. One of the reasons that claiming early is a big mistake is the very nature of Social Security. Unlike other assets, it's guaranteed to increase each year, provided there's a cost of living allowance. And unlike your other resources, you're not going to outlive your Social Security. More and more of our clients are living into their 90s, so Social Security protects against this longevity risk. Now, some are concerned that Social Security may not be there in the future, at least in its current form, but I think we can agree that for our current wave of 60-something retirees, that's not a great concern. Seniors do represent one of the most consistent voting blocs, and any politician who really cares about getting reelected is unlikely to tamper with their Social Security benefits. I think any changes to the system are likely to affect my generation and perhaps younger generations. Now, the math associated with the timing of Social Security is crucial. If you take early retirement at age 62, the maximum reduction is 25% of your benefit. For somebody who has a monthly benefit of $1,000, the reduction could be $250 a month. And for those who delay retirement after the full retirement age, the credit is 8% per year. So that's an additional 32% if you wait until age 70. Again, with some simple math, if you had a full benefit of $1,000 a month, that's an increase of $320 per month. It's important for our clients to know that the amount they receive when they first get their benefits is permanent, and any cost of living adjustments are based on that number. Of course, delaying may not be right for all clients. The Social Security Administration has some factors to consider on their website. They include current cash needs, health situation, other income sources, future financial needs. Unfortunately, most seniors are making their decision without doing any research. They don't realize that financial advisors have access to computer programs, that they can lay out a whole host of strategies to help them maximize their benefits. They fail to appreciate that this is really one of the most important financial decisions they will make about their retirement. All right. I have another topic that didn't make it to the slide presentation. And I had this really great photograph that I wanted to put on the slideshow, but I didn't make it. Does everybody know that grumpy cats can make you a lot of money? When I was young, Garfield was a big hit, cartoon and the like. But apparently, cranky cats, and this is a calendar I found called Cranky Kitties, is big business on the internet and other places. I mean, this calendar has cranky and moody cats for every month of the year. At the top of the feline curmudgeon heap is none other than a cat called Grumpy Cat. Is anybody aware of this cat? I found it online the other day. Yes. He's an internet star who makes probably more money than anybody in this room. He's successful because he's a cat, and apparently he looks grumpy. His owner made the news recently by disclosing that she was making millions on his image. Who knows if she is, but she's apparently making some money. And by the way, his real name is Tartar Sauce. Apparently, Grumpy Cat is a stage name for the cat. I don't have a full picture of him, but that gives you an idea of what he looks like. He's just a sourpuss-looking cat. His owner was apparently managing his millions of dollars through trust planning. She apparently created a trust, and that took ownership of his licensing deals, including those for a movie and other endorsements. Now, unless you're so lucky to have a funny-looking cat or dog that makes millions of dollars for you, this sort of planning really isn't all that practical. But pet planning, planning for your pet, is in fact a practical topic that a lot of my clients are interested in. Occasionally, my clients ask about estate planning associated with who's going to care for my dog or my cat when I'm ill, or perhaps when I pass away. In some cases, they set up informal arrangements with their kids and say, okay, you're going to take the dog, right? No, you're going to, In other cases, they want a formal arrangement if there's a friend or a relative or other relative involved. Here are some common sense areas, if you have somebody who's interested in this, that they may want to address. First of all, address pets in the power of attorney. Some powers of attorney are stock documents that don't mention pets. Others have good powers of attorney that mention the care of animals. In the event you're incapacitated due to illness or you're incapacitated due to an illness or injury, your agent in the power of attorney can do the following: take custody of the animal, spend your money on your animal, find a suitable home for the pet to live. And sometimes vets will want to see the power of attorney. When you bring Fluffy into the vet, they want to know, who are you and why do you have Fluffy? And do you have the authority to authorize the care of tartar sauce or whoever it is? Provide for transfer of ownership at death. Some people do mention pets in their will. Some documents just say, I leave my pet to the following person with a sum of money. Others have a more complicated arrangement, a pet trust. With a pet trust, the caregiver of the pet is named along with a trustee who's going to expend the money. The idea of the trust is that if there's any money left, it then goes to a charity, like the SPCA at the death of the pet. And also, you could use a letter of instruction. These are documents that we use for our clients, typically to give instructions for their loved ones about what they want to have happen to their needs after they pass, or who is their lawyer or financial advisor. But you can also put instructions in there for your pet. Some popular topics that people are putting in their letters include the name of the vet, the date of birth and microchip information, medications, any allergies your pet has, habits like sleeping, preference for a guardian of the pet, preferred home for the pet. So all those things we put in a letter of instruction. As with all estate planning, communication with family and friends is key if you want these plans to be carried out as you intended. I, of course, am hoping that my rather moody basset hound can make me a lot of money and afford me a comfortable retirement. All right. And I think, yes, we do have time for 7 Degrees of Michael Keaton. You've heard of 7 Degrees of Kevin Bacon, yes? We start at one point and we end back with the actor. Now, I mentioned Michael Keaton played in the 1989 Batman film. Do you remember who the leading lady was in that film? She was a blonde. No, it was not Michelle. Sorry. She was in, among others, Kim Basinger. Thank you very much. There you go. And she was married for a brief period of time to an actor who was known for ranting and raving on airplanes and getting into fights with paparazzi as much as he was acting. Alec Baldwin, yes, the most talented of the Baldwin boys. Now, in the first Batman movie, the Joker was played by what iconic actor? Jack Nicholson, that's right. Fast forward years later, both Jack and Alec Baldwin starred in a Martin Scorsese film about the corruption in the Boston Police Department and the Boston mob. Do you remember the name of this movie? The Departed, that's right. In The Departed, there was an obnoxious character named Dingham, played by a local Boston actor, who originally was known as a rapper and an underwear model, whose famous part was Dirk Diggler. Mark Wahlberg, that's right. Mark Wahlberg was in a movie with Will Ferrell called The Other Guys, one of the last Will Ferrell movies that was any funny. But he was in this movie about 2 bumbling cops. He and Farrell were 2 bumbling cops who were trying to make their mark in the police department, and there was a police captain in that movie. Does anybody recall who the police captain was? There you go, Michael Keaton. And for bonus points, if you saw that movie, Michael Keaton was moonlighting at another job while he was also serving as the police captain. Where was he working? Bread, bed, bath, and beyond. That's right. Thank you so much. That concludes the Elder Law Update.
surprise winner, so you really need to be quiet. I knew that would do it. Okay. The North Central Pennsylvania State Planners Council brought a basket and also assisted with the credits this morning. And the winner of the basket, that you can pick it up on the way out, is Corey Buckles. So, yay, Corey. Well, it's my pleasure to introduce Captain David Young. He's from the Pennsylvania State Police, and he's the commander of 8 stations that cover a 9-county area in Pennsylvania. His former position was the commander of the Criminal Investigation Section, Troop F in Montoursville, and he oversaw the Troop Criminal Investigation Units, which include, if you watch TV a lot, vice and narcotics, intelligence, polygraph, forensic services, criminal investigation assessment, and the fire marshal units. So he was pretty busy, and he still is. He has 25 years of service with the Pennsylvania State Police, with over 17 years of experience in the Criminal Investigation Unit. We're pleased that he's here to update you and give you some information on elder abuse and scams, so please join me in welcoming Captain David Young.
Good morning. First of all, any attorneys are going to have to leave the room. It's a police thing. When I was asked to speak, I thought, okay, I can do this. And I began to do some research regarding elder abuse and going back on my experience throughout my career regarding investigating crimes of elder abuse. It brought back a lot of memories as far as what type of cases I've seen, what our investigators have seen, and what we will see in the future. So elder abuse and neglect have risen dramatically over the past 10 years. Although this may be due partially to increased awareness of the problem and the need to report, the increase may also be due to a rise in family tension, poverty, drugs and alcohol abuse, and decrease in availability of community services. The most prevalent types of elder abuse are caregiver neglect, self-neglect, with physical abuse and financial exploitation also accounting for a significant portion of the cases. Elder abuse and neglect are prevalent in our society, and yet it is estimated that only 1 in every 14 cases of elder abuse are reported to authorities. That's 1 in 14. Therefore, it is very important that people of all ages be aware of what elder abuse is, how to spot it, and where to get help for the elderly person in need. The Attorney General's Elder Abuse Unit investigates and prosecutes those who cheat, deceive, or abuse older Pennsylvanians. The unit is comprised of prosecutors, agents, and support staff. A specialized section within the unit educates the public about senior fraud and teaches them how to avoid being victimized. To file an elder abuse complaint, call this number. It's very important. 1-866-623-2137. Again, that's 1-866-623-2137. The Commonwealth of Pennsylvania has the 3rd highest percentage of elderly residents in the United States, with nearly 2 million residents over the age of 65. Statistically, senior citizens are favored targets for many kinds of consumer fraud, including identity theft, charities, telemarketing, and sweepstakes fraud. The Public Protection Division of the Office of Attorney General addresses those types of consumer complaints, as well as health care issues, violations of the Pennsylvania Do Not Call law, and numerous other subjects. In addition, the fastest growing segment of Pennsylvania population is those who are over 85 years of age. Frail and care-dependent elderly are often susceptible to other forms of abuse, including physical and mental, financial exploitation, and neglect. The Criminal Law Division in the Office of Attorney General investigates provider fraud in the Medicare program, insurance fraud, and other crimes. Because various state agencies, including local law enforcement, criminal investigators, and prosecutors work together to resolve cases of elder victimization, it may be difficult to know where to report in certain elder abuse cases. A toll-free elder abuse number, which I gave you, would be the first avenue in which to report that. Any neglect, financial exploitation, or victimization of an older Pennsylvania citizen can provide necessary assistance to help address your questions efficiently. A couple myths that I've seen about elder abuse. A myth: most crimes against the elderly are violent crimes that result from being in the wrong place at the wrong time. The fact of the matter is, most elderly victims are victimized in or near their homes and are victims of financial crimes, neglect, and white-collar crime. Elder abuse only happens to women or older people who are isolated, frail, or have a disability. Fact: abuse can happen to anyone and can come in many forms other than physical harm, including financial and emotional. Myth: only a stranger would abuse an elderly person. Fact: the abuser is often a loved one who the elderly person trusts. Myth: if things were really that bad, then the victim would just leave. Fact: oftentimes the victim feels trapped as a result of many factors, including fear, isolation, social repercussions, emotional dependence, and low self-esteem. Most victims of elder abuse are victims of physical abuse. Fact: though physical abuse is the easiest form of abuse to recognize due to the appearance of physical marks, other forms of abuse occur as well and can be recognized through behavioral changes. Myth: elder abuse is similar to child abuse. Fact: elder abuse is more similar to spousal abuse than child abuse in terms of types of abuse perpetrated. Types of elder abuse: physical abuse, hitting, unnecessary restraints, pushing, intentionally causing pain, causing injury, and intentional misuse of medication. Sexual abuse, the forms: inappropriate exposure, inappropriate sexual advances, inappropriate sexual contact, sexual exploitation, and rape. Forms of emotional abuse: humiliation, threats of harm or abandonment, isolation, non-communication, and intimidation. Financial abuse: under the influence to change legal documents, misuse of property, theft or embezzlement, identity theft, and theft of medications. Neglect: deprivation of basic needs, including water, food, housing, clothing, and medical care. So as I outlined it for you there, those are what we see in the law enforcement community and what we respond to. I'd like to explain a little bit to you now regarding the law enforcement response as far as reporting goes and the ultimate goal of taking the case to the district attorney for prosecution. As far as reporting goes, it begins with the caregiver or family member, and I can't stress enough, immediate reporting is key to any investigation. If you believe something is wrong, if you feel something is wrong, report it. Very simple. If you wait, evidence is lost, memory is lost, we fall so far behind. Initial police response will vary depending on what is being reported. For example, if you have a report of a theft, fraud, or forgery that occurred 2 weeks ago, you'll see the uniformed trooper in the marked car come to the location, take the information, do a report, do the interviews. However, if you see a more complex case, a large theft, fraud involving thousands of dollars, sexual abuse, or rape, you will see what we call as a criminal investigator respond to the scene. That investigator will be dressed in a suit and tie, and he will assume primary responsibility for that investigation from the beginning. It's important to know that because that would be his sole case. No one else will touch that case but him. He's devoted to that case and will see that case through the trial court. With that being said, even though the patrol trooper, as previously stated, responds to the scene, if he uncovers information or the investigation shows that there is more to the initial complaint than what is believed, it will then be assigned to a criminal investigator who, again, will take over the case and take it through the district attorney. A couple investigative steps that we look at. First of all, we have to determine a victim loss. If there's bodily injury, that's not a loss, however, that is an assault. Suspect identification. Who is it? Who are they? Where are they? Evidence documentation. Collection, notation, very important, as I stated previously, evidence can go away. If you have someone visiting an elder person who leaves a cup of coffee on the table, and you believe the elder person was raped or victimized, and you don't report it right away because you don't think it happened, and then she goes and washes that cup, we just lost DNA evidence. Very important. Upon the investigation being completed by the criminal investigator, there's what's called a presentment to the district attorney. There's 4 things the district attorney can do or tell us to do with the case. Number 1 is an arrest. And as you all know, you need probable cause to make an arrest. Number 2, you would close the case due to lack of probable cause. Now, when I say, if you understand, I know you all understand the word close, but in police terminology, close means we're no longer investigating. However, that does not mean if new information comes to light, we cannot reopen that case and continue the case once the new information has come forth. But with that, you also have to understand that if you have a forgery and it happened 2 years ago, and 4 years later, you find out additional information regarding the forgery, we're outside the statute of limitations, okay? Most felonies are a 5-year statute of limitations, and most misdemeanors are a 2-year statute of limitations.